Good evening, everyone, and welcome to the BicTok session 33. And this session is titled Handling Jurisdictional Challenges in Domestic and International Arbitration. And my name is Michelle Wong, and I'll be your host for today's session. And before we begin, let me run through a few housekeeping matters. So, firstly, kindly ensure that your Zoom username reflects the name under which you registered, and this will allow us to mark your attendance accurately and, where applicable, issue your certificate of participation and as well as for your CPD points. Secondly, if you have any questions during the session, please feel free to leave them in the chat box and we will read them out at the end. And now it is my pleasure to introduce our moderator for today's session, Mr. Dayanandan Bhaskaran. Mr. Dayananda Bhaskaran is a partner of Bhaskaran Kuala Lumpur and a door tenant and head of Southeast Asia at International Construction Chambers, London. Mr. Daya's primary area of practice is construction law, and he also sits as arbitrator, adjudicator, and mediator. He's also the author of Arbitration in Malaysia, a commentary on the Malaysian Arbitration Act, and has held various leadership roles in arbitration organizations in Malaysia and abroad. So without further ado, I'll now hand over the session to Mr. Bhaskaran.
Thank you, Michelle, for the very kind introduction, and to BICAM for inviting us all to be here this afternoon. This afternoon we will be talking about handling jurisdictional challenges in domestic and international arbitration. So all of you who are involved in arbitration would have come across jurisdictional challenges, unfortunately, quite frequently in practice. Some of these challenges are fairly substantive, based on issues arising from the arbitration agreement, where for some reason the arbitration agreement is defective or unenforceable. And in other instances, it arises because the dispute has simply extended beyond the initial reference to arbitration. So this afternoon we have three very eminent speakers who will be taking us through this very interesting area of jurisdictional challenges in arbitration proceedings. If I may introduce them, first we will have Nicholas Hall. Nicholas is an advocate and solicitor of the High Court of Malaya. His areas of practice include construction disputes, medical malpractice claims, disciplinary proceedings, and commercial disputes. Nicholas is a fellow of AIADR and is empaneled as an adjudicator with the AIAC. He is also a legal advisor to the Malaysian Medical Council and a member of the Advocates and Solicitors Disciplinary Board. Mr. Nicholas will this afternoon be speaking on introduction to jurisdictional challenges and counsel's experience. Perhaps I'll introduce the speaker just before they speak. So without further ado, perhaps we can hear from Nicholas.
Thank you for the very kind introduction, Taya. Let me just share the screen. Right. Right. Can everyone see the slides? Okay. Oh, yeah. I'll start then. I will be giving a presentation, the very basics of on this subject, and then I'll let the other eminent speakers go into more details on that. So just to go through the outline for my talk today. Four matters. Number one is on what is jurisdiction. Now, secondly is on the principle of competence. Thirdly, determining whether there is jurisdiction, and fourthly, talking about the timing and the manner of jurisdictional challenges. Right. So before I start, I'd like to pose a question for brainstorming. right? If you're an arbitrator or if you're a counsel attending today, suppose one day a two parties or a party approach you, wanting to appoint you to be an arbitrator or a counsel for that matter, and the party tells you that the arbitration agreement or the arbitration clause is written in Jawi, and it was in fact made in the year 1878. And the claim is for US dollars 15 billion dollars. Now, what would be going through your mind? Would you take up the appointment?
Contingency basis.
Yes. That would be that would be a question that would be in your mind, in our minds. Yeah. So so this, in fact, is based on a true story, if I might say it. And if you're familiar with the case, the arbitration case of the heirs of the Sultanate of Sulu and against the government of Malaysia, this is precisely what happened. And there was an arbitrator from Spain appointed and so on. And we'll talk more about this, but one of the main issues that you want to consider is whether
Thank you.
you would have jurisdiction, right, to decide or determine the dispute. Now, first of all, let's go to the very basic. What is jurisdiction, right? Because jurisdiction means different things to different people in different forums. But so far as arbitration is concerned, jurisdiction refers to the tribunal's mandate or authority or competence, we call it, to hear and decide a dispute in arbitral proceedings. Now, the tribunal's jurisdiction primarily is conferred by the arbitration agreement between the parties. This is, you can see this under Section 4 of the Arbitration Act 2005. Now, of course, tribunal which lacks jurisdiction risks being removed or not being clothed with the jurisdiction and having the proceedings invalidated. Now, when we talk about jurisdiction, we are referring to the authority or the mandate, and we are not so much talking about the powers, right? Of course, once you have the jurisdiction, then we then go on to decide on whether you have the arbitrator has the power, for example, to grant interim measures or award costs and so on, right? So we use, or at least for this talk, we are using these two terms. We're distinguishing between these two terms. Now, moving on, we go to the doctrine of competence. Now, the spelling here is the English, of course, is spelled as COMPETENCE, and the other term is from the German language, right? And so basically, this doctrine says that the arbitral tribunal is competent or is clogged with the jurisdiction to decide on its own jurisdiction, right? And so this includes on whether there is the existence, whether there is existence, validity, legality, or scope of the arbitration agreement. Now, we usually see this in two different perspectives, positive and negative. Positive basically is that the positive aspect is in the sense that the tribunal is competent to preliminarily decide all jurisdictional disputes. Of course, this competence is subject to review by the courts. Now, in terms of the negative aspect, when I say negative, we don't mean it's a disadvantage. What we're saying is that there's a different aspect to it, which is the courts cannot decide on the tribunal's decision prior to the tribunal's own determination, right? This is provided or inferred from the provisions of the Arbitration Act itself, the Section 8, and also perhaps you could say under Section 10, because when a party goes to court, the defending or responding party can say, no, I want the issue of jurisdiction to be decided by an arbitral tribunal, because I don't think that we should go to court because that's an agreement for arbitration. And yeah, so positive and negative aspects. And of course, the doctrine itself is enshrined in Section 18 of the Arbitration Act, as well as under Article 23, sub 1 of the arbitral rules. Now, this is just a non-exhaustive list of all the different rules from different jurisdictions, providing for the doctrine of competence of the tribunal. So a few examples would be the BICM rules under Rule 17, the AIC rule, which adopts the arbitral rules, and the SIAC rule. We'll talk more about these rules shortly, but let's go on to the determination of whether there is jurisdiction, right? So three things that we will talk about today. Of course, there are more things that we can consider if we had a longer session, but I just want to focus on three things which is mentioned in Section 4 of the Act. Firstly is the agreement. What is agreement? What is the subject matter that has been agreed for the arbitration agreement, right? That's where primarily the tribunal get its jurisdiction. And also under Section 4, there are two matters to consider. One is whether the arbitration agreement would be contrary to public policy. And thirdly, whether the subject matter of the dispute is capable of settlement under arbitration under the laws of Malaysia or not, right? Now, the first thing we look at is the scope of parties' agreement, i.e. what is the subject matter that has been agreed upon to be arbitrated on, right? So that's where the jurisdiction of the arbitrator will lie, right? So for example, if a contract says, okay, parties agree that if any disputes rises out of this agreement, parties agree to go for arbitration, for example, then what it means by disputes arising out of the agreement, right? What it means by in connection with, what it means by in relation to, right? These are the linking words that commonly found in the contracts, and our in short, our courts have interpreted such clauses widely or broadly, right? So for example, in the case of state government of Sarawak and Chinhua Engineering, federal court held that where words such as in respect of or with regard to is used, it will give the arbitrator jurisdiction to decide all allegations of breach of contract by either party, right? Now, what if the parties argue? What if the arbitration agreement says that only where there is a part where there's or what if the clause says that there's a if only there's a dispute, parties go for arbitration, and one party now says no, there's no dispute, everything has been admitted, the liability has been admitted, we don't want to go for arbitration, we want to go for court. Now I've been involved in cases such as this, and in cases such as this, the federal court have said that the issue of whether there's dispute or not is also something to be decided by the arbitral tribunal, meaning to say the tribunal would have the jurisdiction to decide on that. Similarly, when there's a complaint or allegation that the contract is terminated, and the contract is where the arbitration clause or the arbitration agreement lies, right? So now, what happens then? What happens if the arbitration clause is always, most of the time will be found in the main contract or the contract where the parties have entered into, but now someone claims that, oh, it's void, or if it's terminated even, does the arbitrator still have jurisdiction to decide on that? And the answer is yes, because under the principle of separability, the arbitration agreement or the clause is distinct and collateral to the main contract, right? And this is provided under Section 9 sub 2 and 18 sub 2 of the Act. Now, when it comes to arbitration agreement, let's get back to our case of the Sultanate of Sulu. And this is the this Jawi writings is the agreement itself, in fact, and part of it has what we call the arbitration agreement or the clause, right? And it says, in case any dispute shall arise between His Highness the Sultan, his heirs or successors, and the State Gustavus Baron de Overbeck, his heir or assigned, the matter shall be referred to the decision of Her Britannic Majesty's Consul General for Borneo. So if you appointed arbitrator in this case, do you think you have jurisdiction to decide on the dispute? And the French or the cassation or the French Final Court of Appeal said no, right? Because of the disappearance of the office of the British Consul General has made the clause obsolete, right? And so now there's no longer, or the absence of an agreement, and the decision of the judge of support, the judge who appointed the arbitrator, cannot be invoked. Of course, there's a long history to this, but in short, part of deciding on jurisdiction or jurisdictional challenges would be deciding on, at times will be deciding on whether the arbitration agreement or clause is effective or applicable, close jurisdiction on you or not. Now, the third element is whether it's capable of settlement by arbitration under the laws of Malaysia, right? So in the case of Peninsular Education, the Court of Appeal says that the Act recognizes there are certain subject matters that are not arbitrable under the law, or which arbitration agreement would be contrary to public policy. Some of these matters include dissolution of marriage, adoption, judicial review, and so on, so on. So there are certain matters that are specifically excluded from being arbitrated. Sometimes it's not very clear, right? Sometimes it's not very clear because Section 4.2 in fact says that just because the Act says that the jurisdiction lies with the courts doesn't mean that the arbitrator have no jurisdiction. So you have to look at case laws, you have to look at the policies and the sentiment of the day, right? And of course also arbitration agreements that are contrary to public policy would also not be applicable and would not clothe jurisdiction on the tribunal, right? For example, certain investment, I put quote unquote investment disputes, and because certain investment agreement dispute in fact are money lending agreements, and in Malaysia, the public policy is that illegal or money lending agreements are illegal unless certain elements are satisfied. So in Malaysia, it might not, it might be against public policy for it to be arbitrated, but not in Hong Kong or some other jurisdictions, perhaps, right? That is something that I've came across also previously, and of course, gambling disputes and some competition disputes. Some courts from other jurisdictions have frowned upon, but gradually over the years, policies and sentiments change, and eventually, or from what I read nowadays, courts are more inclined to allow jurisdiction on competition disputes, for example. Other types of jurisdictional challenges that may not be from the agreement are things like challenges on the limitation on res judicata. There's the recent Court of Appeal case, I think, that talks about this, the One Amrin resident case, or premature claims, or failure to obtain consent from liquidator for liquidated companies. And one other thing is the failure to release the award within the agreed time, and that is more of the post-commencement issue. Sometimes jurisdictional challenges are made are only arises after the arbitration commence, right? I think my time is almost up, but I'll just quickly go through the timing and manner of jurisdictional challenges. Section 18.3, plea that arbitral tribunal does not have jurisdiction shall be raised not later than the submission of statement of defense. And if a plea is on the exceeding of the scope of authority, it shall be raised as soon as the matter alleged to be beyond the scope is raised. And however, the tribunal does have the leeway to consider these challenges beyond the prescribed time if the delay is justified. And very important issue is the plea can be decided as in the form of a preliminary issue or question, or in the awards on the merits itself. Of course, when we say the no later than the submission of defense, it will also include for counterclaims, responses to counterclaims, right? And this is not provided in the Act, but it's inferred and it's been captured under the UNCITRAL rules. Few matters to consider. Firstly, if your counsel lodge the jurisdictional challenge as soon as possible, as early as the notice of arbitration, because if you don't, and if you fail to do it within the prescribed time, you might be barred from raising it later. And if you want to raise it later on to set aside a final award, you might be also prevented because you would have been to have waived your rights. Now the second question is whether the challenge should be dealt with as a preliminary question or in the final award. Now this depends, but bear in mind that the right to appeal under Section 18.8 is only in respect of plea as a preliminary question. So if a party cannot sort of appeal based on Section 18 if the issue of jurisdiction is dealt with in the final award. And of course, another question that we would want to consider if you're arbitrator is whether to continue or stay the proceedings in the event of an appeal to a decision you made with regards to jurisdiction. Of course, claimant will always want to continue, and respondent may want to stay right? Most importantly, of course, is for both parties to have a right opportunity to address you on whether to continue or stay. Other than that, you have the right to decide, the discretion to decide on this issue.
Nicholas,
Another thing.
Nicholas, now that we are on your slide on timing, we've come to perhaps
Thank you. My last slide.
terribly
My last slide.
interesting, but
Sorry.
yes, if you can perhaps
Yeah. I'll wrap up in 1 minute. Thank you. So the last thing I want to say is on the now when it comes to challenging the jurisdiction, there is also under some of the rules, for example, the AIC rules or the Hong Kong arbitration rules, what we call the summary determination or early determination procedure. So the counsel don't necessarily need to challenge it just write in sort of like an application, but there is a prescribed procedure on how to deal with this, sort of like a summary disposal of case or summary judgment, sort of in a manner where there's a manifest, where the point is where it's clearly or manifestly outside of the arbitral tribunal's jurisdiction. Right. So that's one thing that counsel and the arbitrator will want to consider. Of course, this is on request by the parties only. Okay, I think that's all my slides. Sorry for overextending the time a bit. I shall pass the time back to Taya. Thank you.
Thank you very much, Nicholas, for that very illuminating introduction to jurisdictional challenges and to speaking about the concepts of competence, and the separability of arbitration agreements, and the very interesting area of arbitrability, where some types of disputes just cannot go to arbitration, criminal matters, family matters, as well as in Malaysia, certain land matters. So now we go to the second speaker, Mr. C.K. Oon. He will be speaking on arbitrators' experience of jurisdictional challenges. And if I can introduce Mr. Oon. Mr. Oon Chee Keng is the principal partner of C.K. Oon and Company. He holds 3 degrees, namely a bachelor's degree in civil engineering, a bachelor's degree in law, and a master's degree in business administration. He is a former vice president of the Institute of Engineers Malaysia, besides holding other posts in the said institution. Mr. Oon was admitted to the High Court in Malaya as an advocate and solicitor in 1995 and is currently a member of various committees in the Bar Council, such as the Construction and Arbitration Law Committee. Mr. Oon is also a fellow of the Institute of Engineers Malaysia as well as CIAB. He also sits on various committees in the Construction Industry Development Board and other bodies. He was at one time an external legal consultant to the Public Works Department. Mr. Oon has appeared as counsel in arbitration and litigation cases, some of which have been reported in the law journals. Apart from that, he has also acted as mediator, adjudicator, and arbitrator. So, Mr. Oon, the floor is yours. Mr. Oon, I think you are muted. I'm afraid you're muted.
Okay, sorry. Okay, thank you, Taya. Can you hear me now?
Yes, I can. Thank you.
Yeah, just a small correction, okay? It's an Institution of Engineers Malaysia, not Institute Engineers Malaysia. Okay, just a small correction there. Anyway, thank you. Now, what I will be speaking today in relation to the topic of today's talk, right, on jurisdictional challenges in arbitrations. Now, I will divide my talk, next slide, please, into 3 parts. Firstly, I'll quickly run through what amounts to jurisdiction. Then I will look at the questions of jurisdictional challenges from the perspective of, firstly, from the perspective of the parties or from the perspective of their counsel. Then I'll look at the questions of jurisdictional challenges from the perspective of the arbitral tribunal. So inevitably, I may I may trespass into the area I already touched on by Nicholas, but okay, please bear with me. Next slide, please. First thing, what is jurisdiction? Now, Nicholas just now, right, okay, has already elaborated on certain aspect of this question as to what is jurisdiction. And also, right, okay, the question of jurisdiction is not that simple and clear-cut as it seems. As we said just now, right, okay, the question of arbitrability of the dispute may also have effect on the issue of jurisdiction of the arbitrator. However, right, I can do no better than quoting from Justice Abdul Aziz, one of our more eminent judges, in the case of Savage Consulting Engineer Rangi Bersekutu, where his lordship said, let me quote, by jurisdiction, I mean arbitral domain. That is to say, the kind of matters that an arbitrator is required to arbitrate in a particular case, and the kind of people between whom he is to arbitrate those matters. It is very important in this case to distinguish jurisdiction in that sense from the powers of an arbitrator. Now, let me pause here. So, the questions of jurisdiction and the question of powers must be appreciated. The distinction is important. You may have the powers as enshrined in, for example, the rules, but you may not have the jurisdiction to expand those powers. Let me continue what he said. By which I mean the remedies and tools that are available to an arbitrator to use in his arbitral domain. The jurisdiction, and this is important as well, he said, the jurisdiction of an arbitrator is conferred and defined by the arbitration agreement. That is the arbitration clause in an agreement. So, his lordship here has very specifically defined and explained what constitutes jurisdiction. And he also make a distinction between jurisdiction and power. And he also explained where that jurisdiction of the arbitral tribunal come from. Next slide, please. So if you look from this perspective, right, okay, now, if a jurisdictional challenge is raised, now, that challenge, if successful, may bring the whole arbitral process to a halt. Because when arbitral tribunal, when faced with this question and is put to him to make a ruling of this, and if he said yes, and if he concludes yes, I don't have the jurisdiction, that may be the end of the whole arbitral proceedings. Because devoid of jurisdiction, the arbitrator or the arbitral tribunal cannot proceed. Therefore, if you look at this, right, okay, the whole questions of jurisdiction may be an important issue, may even be an important initial issue, which may be faced by the arbitrator and which may be raised by the counsel or the parties to the arbitration as well. Now, next slide, please. So, I will make a distinction between what I call a substantive jurisdiction and what I call a procedural jurisdiction. Okay, and as to what constitutes procedural jurisdictions, I will explain later on. Now, just now Nicholas has also talked about the arbitrability of the disputes. Okay, now, but the question is just now, right? And from the quotation which I have cited just now on the jurisdiction and where does the arbitral jurisdiction stem from? As said, okay, it's from the arbitration agreement. Now, what if the arbitration agreement is invalid? Or in a very normal phrase, right, is void, inoperative, and incapable of being performed. So this question here, if the arbitration is not valid, that means there is no arbitral jurisdiction. But this the distinction has to be made between the invalidity of the agreement that contains sustains the arbitration agreement. There is a difference there. And I think Nicholas has also touched on it just now. And also, right, they asked instances where arbitration agreement have been incorporated by reference. What if there have been some invalidity in incorporating the arbitration clause or arbitration agreement inside the agreement itself? So this have been illustrated in not a very recent case of Daewoo and Bauer, where His Lordship Gopal Sri Ram has also said on this. And if it's not incorporated, right, there cannot be an arbitration clause. And devoid of the arbitration clause, the arbitral tribunal is devoid of any jurisdiction. Now, the other thing, and which is, I think it's more practical and more common, is this. If you look at some of those arbitral agreements or arbitral clauses, it's in the form of what I call a multi-tiered dispute resolution clause, i.e., you must secure the final decision from engineer or the SO first. Then you go for meeting or negotiation between the top two fellows in the company, in the two disputing parties. Then go for mediation. And if that fails, then go for arbitration. Now, each and every step will have to be go through first before one can commence arbitral proceedings. Now, take a very simple case of, for example, JKL contract. Now, if you look at JKL contract, right, it's stated that you must have this final decision from the SO first before you can commence arbitral proceedings. Assuming that, what if a party who initiates the arbitral proceedings has not obtained or the SO has not given the required or the allegedly required final decision? Now, in a not so recent case of USA Summer, Justice Lee Swee Sing in the High Court, as he then was, said, no, this goes to the heart of the matter, and if the final decision of the SO has not been acquired, or if the SO has not given his decision, then the arbitral tribunal has not acquired any jurisdiction as far as the dispute in the parties are concerned. Now, I want to pause here and ask, should or can a procedural misstep be override a substantive dispute between the two parties just because a decision has not been obtained? And those of you, pardon me just now when Taya said I'm a former legal consultant, the Ministry of Works. Very often SO, right, will drag its feet and will not actually issue the instructions, so to speak. So what is next? So the question is, the development in the international scene has come to treat this, in certain jurisdictions, okay, has come to treat this non-fulfillment of condition precedent, if I can call it a condition precedent, had come to treat this non-fulfillment of condition precedent not as a jurisdictional issue, but as an admissibility issue, i.e., the whole case will still go before the arbitral tribunal, and whether the whole issue between the two parties have been properly placed before the arbitral tribunal, so to speak. And the arbitral tribunal will be the party, will be the one who decides on this issue itself, taking all the whole arbitral steps into consideration. But having said so, right, okay, I must also highlight one federal court case that seems to support the USA-Sama approach, and to say that the precondition steps before commencing arbitration, right, will have to be adhered to. Okay, but maybe when time comes, okay, I hope maybe our court can revisit this position. Next issue, please. Now, some arbitration agreement, they specifically provide that the arbitrator must be, for example, a medically trained personnel, or must be an engineer, so to speak. Okay, and I've seen some arbitration clause, right, they said the arbitrator must be legally trained and must be a barrister. So in this sense, right, okay, if the arbitrator who have been appointed is not as per the arbitration agreement or is not as per the requirements set out in the arbitration clause, then the arbitrator is also devoid of any arbitral jurisdiction. And also the disputes are not within the arbitration agreement. Just now Nicholas has talking about the very common phrases used in arbitration clauses, for example, in connection with, arising from, etc. And the trend, the jurisprudence in this area, right, has tended towards interpreting this very broadly, and it will be difficult to argue that any disputes do not form or do not fall under the arbitration agreement by giving a restrictive interpretation to those clauses. The former 1952 regime in Malaysia arbitration, right, may have, and the old cases may relate to this, but the recent cases tends towards giving a very broad interpretation to all these phrases. Now, having said so, right, on the question of jurisdiction, now the lack of 2I does not affect jurisdiction. Does not affect jurisdiction. When I said 2I, right, okay, independence and impartiality. If the arbitral tribunal lacks independence and lacks impartiality, the 2I, that itself does not mean that they are not seized with jurisdiction. It is just a case of you can apply under Section 15 and raise justifiable doubt to ask for their removal. But this itself is not a question of their lacking in jurisdiction. Now, as stressed by Justice Lee Swee Seng in the case of JMSB and PSB, okay, this application or this challenge to the impartiality or independence of arbitrator with raised justifiable doubt is a challenge under Section 15. And this Section 15 challenge must be distinguished and is distinct from a challenge to remove an arbitrator or to tell the arbitrator that he is devoid of any jurisdiction. And this later part here is governed by Section 18. Now, the other thing which can encroach into the issue of jurisdiction is this. Let me give me a scenario from a recent case. If, and very common, right, construction project, a contractor will be given 1, 2, 3, 4, 5, 6 works orders. Okay? Now, all relating to the same project. And if dispute arises between the contractor and, for example, the main contractor, then quite common or quite normally done. And each of these work orders will have its own arbitration clause. So if the contractor or the subcontractor, right, issue one arbitral notice invoking the arbitral clauses of all these 5, effectively and essentially consolidating all 5 arbitrations into one arbitration. Now, what is next? In this case, does the arbitrator, even if appointed, have the jurisdiction? My considered answer is no, because as I said just now, the arbitral jurisdiction stems from arbitration clause, and each arbitration agreement has its own arbitration clause, which give rise to each and every arbitration clause, its own jurisdiction. Consolidation, in the absence of consent of all the parties, does not itself grant or confer the arbitral tribunal with that jurisdiction. Next slide, please.
Thank you, CK. CK, we are running, I think we're running slightly over time. So perhaps
Okay.
wrap it up.
I'll try to be fast, okay? Because just now, right? Sorry, I forgot to apply for extension of time just now.
That's fine, yeah. Maybe we can wrap it up shortly so we can.
Okay, our next slide, please. Okay, this procedural jurisdiction, right? Okay, for example, arbitrator, right? Sometimes you only know that the arbitrator has exceeded their jurisdiction when the arbitral award is so-called published. Okay, they have treated issues or decide on issues which are not even pleaded or which are not within the arbitral agreement with the scope of authority. So this type of jurisdiction is to be distinct and differentiated from the substantive jurisdiction which I said just now. Now the question is challenging to arbitral tribunal lack of jurisdiction. Okay, and it is provided that you must raise or at least to record that this jurisdiction must be made not later than the submission of the statement of defense. This is provided for in Section 18.3 Arbitration Act and also in the rules.
Right.
ARBC rules, one of them.
Okay, thank you very much, CK. That has been very interesting, giving us various perspectives on jurisdictional challenges and the ongoing debate on conditions precedent to arbitrations in Malaysia and the interesting judgment in Summer, SPNB, LTAT, which I was personally involved in and found very interesting. So now we move on to the last but not least, Keng Ho. Keng Ho is an advocate and solicitor of the High Court of Malaya, as well as an arbitrator, adjudicator, and mediator, and paneled with the AIAC. Keng Ho is a partner at Keng Ho and Lee Yuen and primarily handles construction disputes. Keng Ho this afternoon will be taking us through various reasoned judgments on jurisdictional challenges. So without more, Keng Ho, the floor is yours.
Thank you, Taya. Okay, obviously time is an issue. Everybody is running out of time, so let's try and rush it. I plan to spend my time just to illustrate one jurisdictional challenge arising from an international arbitration in the context of one federal court case, and that is the case of ING Bank and Tumpuan Mega. So let's move to the next slide, Michelle. All right, so here are some brief background facts. So we all start with the fellow right at the bottom, OW Bunker Far East Singapore Private Limited. That's the second appellant. They entered into two purported supply contracts with this company called Tumpuan Mega Development, which is the respondent, to supply bunkers that will be used to supply fuel to ships. Now, these two supply contracts are subject to English law, arbitration to be in London. Now, the second appellant was a subsidiary of OW Bunker and Trading AS, which is a Danish company. This company had a facilities agreement with a syndicate of banks, of which ING Bank was a security agent. And by an omnibus security agreement, this Danish company assigned all their rights, title, interest in any amounts owed to them and their subsidiaries to supply contracts to ING Bank. So this included the two supply contracts of the second appellant and the respondent. So the Danish company went into liquidation. Receivers were appointed over their assets, including assets of the second appellant. One of these assets would be the amounts owed by the respondent to the second appellant pursuant to the two purported supply contracts. So the reason why I say purported supply contracts is because the respondent says these contracts do not subsist. They say that no bunker was ever supplied under these two contracts. So the appellants, OW Bunker, they started arbitration in London. The respondent objected to the jurisdiction of the London tribunal. According to the respondent, they say if the two disputed transactions did not take place, therefore, the two supply contracts were not genuine. Since the arbitration clause subsists in the two supply contracts, therefore, there was no arbitration agreement. All right, so there's this roundabout argument. 2 years after the London arbitration started, the respondent amended their defense. They say, hey, wait a minute. We just discovered there was another set of agreement which contained an arbitration clause for all disputes to be referred to Malaysian arbitration under Malaysian law. And therefore, this included the two disputes on the two supply contracts. So again, the respondent says, this is a jurisdictional defense because parties have agreed to resolve disputes in Malaysia. Therefore, London Tribunal has no jurisdiction. Okay, next slide. So in essence, in this case, there are two jurisdictional challenges, right? First, London Tribunal has no jurisdiction because the supply contracts did not subsist or the transactions under the supply contracts did not take place. Secondly, the London Tribunal has no jurisdiction because parties have agreed to resolve their disputes in Malaysia. The London Tribunal, under competence, rejected the amendments because it says it's 2 years delayed. However, they say even if you have no delay, the amended defense has no merit because the set-off agreement was to resolve disputes relating to set-offs and it was not supply contracts. Nothing in the set-off agreement override the supply contracts. So that was the decision of the London Tribunal. Next slide. So this is what happened. 4th February 2020, London Tribunal decided in favor of the appellants, both on jurisdiction and on merit. The respondent did not apply to set aside the award in London. 11 June 2020, respondent, very pandai, come to Malaysia and start a new arbitration on the same subject matter, but pursuant to the set-off agreement. The appellants objected. They raised a preliminary objection, PO, say the issues are res. Malaysian arbitration proceedings are an abuse of process. The Malaysian Tribunal agreed with that preliminary objection. They handed down an award upholding the preliminary objections. Respondent then proceeded to file an application to set aside the Malaysian award, which was dismissed by the High Court. It is now pending appeal. Next, the respondent filed proceedings in the English court based on the set-off agreement. They say, hey, the set-off agreement has an arbitration clause that says we arbitrate in Malaysia. You have breached the arbitration clause in the set-off agreement. The English court says this is a hopeless case, struck out the proceedings and said it was an abuse of process. So we take a pause. Let's take a look. Where does the case stand? There is one, a London award based on the supply contracts. Number two, there is a Malaysian award dismissing the respondent's claim based on the set-off contract. Number three, there are legal proceedings by the respondent in England for breach of arbitration agreement in the set-off contract, and that was struck off. Number four, there is now a court order from England enforcing the London award. They call it the confirmation judgment. This was never challenged by the respondent. Now the appellants, having gotten this confirmation judgment, decided to apply to register the English judgment in Malaysia under Reciprocal Enforcement of Judgments Act. This was a very peculiar move because most parties would apply under the Arbitration Act to enforce the arbitral award. But they went under REJA, and the appellants obtained an ex parte order to register the High Court, the English High Court judgment. Now, because it is registered ex parte, the respondent can no longer ignore the London award. So they applied to set aside the registration of the English High Court judgment under REJA because they say the English High Court has no jurisdiction to confirm the London award because the London award was issued without jurisdiction. And therefore, the High Court judgment was obtained by fraud because there was no jurisdiction in the first place. So this one big circular argument, right? In the midst of the application to set aside, the respondent says, hey, I want to have an application for trial. You're allowed to, in a REJA application, under Order 67, Rule 9 sub 2, the issues for trial that the respondent identified is the same issue as in the London Tribunal. The High Court dismissed the application for trial. Matter went to the Court of Appeal, and lo and behold, Court of Appeal agreed with the respondent, allowed the appeal. So this is what the Court of Appeal says. The Court of Appeal says, look, we have a specific statute, which is the Arbitration Act, governing arbitration. And REJA, therefore, is not applicable. So you say, yes, the Arbitral Tribunal has already decided that they have jurisdiction. So they have dismissed the jurisdiction claim. But any decision of Arbitral Tribunal on jurisdiction is never final. It's always open to challenge in the court of the seat. That means where the award is registered, or in the enforcement court. So in a domestic arbitration, the seat court and enforcement court are always the same because we always hear it together. But in an international setting, the seat court and the enforcement courts can be different. So the challenge at the seat court, they call it an active challenge. It is a challenge to set aside the award. The challenge at the enforcement court, they call it a passive challenge. That means you wait for people to try and enforce, then your challenge is to resist the recognition and the enforcement. So again, domestic arbitration, no difference. Both are heard together. International arbitrations, they are heard separately. So an overseas award debtor, they could choose either to set aside the award at the seat court, the positive challenge, or they can raise the issue of a lack of jurisdiction by reason of the absence of a valid arbitration agreement to resist the registration of the award at the enforcement court, passive challenge. And because there is a case, Dalla Real Estate, he says, if someone says, I'm not a party to an arbitration agreement, they have no obligation to participate in any arbitration or take any steps. So you can't say they are estopped and so on. Estoppel doesn't apply. So Reja cannot apply. Court of Appeal said Reja cannot apply for judgments to enforce foreign arbitral awards. And he says even if Reja were applied, the respondent can still raise issues of jurisdiction. The Court of Appeal says, let's hear the issues of jurisdiction de novo. That means we have a rehearing of it. And they allowed the application for trial. The appellants went to the federal court. Okay, next slide. So these are the issues in the federal court summarized. Number one, is Reja applicable or is a foreign award limited to be enforced under the Arbitration Act? The federal court says registration of a foreign judgment under Reja is governed under Reja, and that does not have the broad discretion to look at the circumstances of the case, because under the Arbitration Act, it is basically following the New York Convention, and there is some broad judicial scrutiny allowed, particularly on jurisdiction. Therefore, Reja is premised on the principle of reciprocity. It is wholly different. It is separate from the registration and enforcement of an arbitral award under the Arbitration Act, and Reja is only applicable to a few states because it has to be by way of a bilateral trade. So the federal court says Reja and Arbitration Act both are separate and distinct modes and avenues for registration and enforcement. Reja for a few select states, Arbitration Act generally. So yes, Reja is applicable. Second issue, does the Arbitration Act as a lex specialis prevail over Reja? There is a specialist law. Well, the Arbitration Act was modeled after the model law. And Article 1 of the model law says it is subject to agreement in force between states. So in other words, federal court says model law gives precedence to multilateral and bilateral conventions, and Reja is the bilateral agreements that Malaysia has struck with various individual states, therefore cannot be excluded. In fact, the definition provision in Reja allows for enforcement of arbitral awards. So a confirmation judgment, that means a judgment that enforces the arbitration agreement, premised on an arbitral award, is still a judgment, and it is expressly recognized under Reja, and arbitral award per se is recognized under the Arbitration Act. There's no conflict, right? So in other words, you go and get an confirmation judgment, you can go after under Reja if it is within the list of scheduled states. If without that, you just take the arbitral award, you can go under Arbitration Act. Arbitration Acts, the federal court says, is not the lex specialist to replace Reja, because Reja itself is also lex specialist, because Reja concerns enforcement of judgments for specific jurisdictions. But then the question is, how about the right of parties to a passive remedy? If you use Reja, wouldn't that bypass the safeguards that are under the Arbitration Act to challenge the registration of the award? So the answer lies in Reja itself. Section 5 Reja says a judgment debtor can set aside the foreign judgment, the registration of the foreign judgment in limited circumstances, including where the original court did not have jurisdiction or where the judgment was obtained by fraud. And the federal court further says, in a confirmation judgment premised on a foreign arbitral award, in order to resist the enforcement, you can't be just challenging the judgment itself. You must also be looking into issues arising from the arbitral award, because otherwise there is no real examination of issues. If you're just looking at the judgment itself, there's nothing to challenge very much. So the award has to be question, and in order for the respondent not to be deprived of their real defenses. And their real defenses in this case is jurisdiction and fraud. So the passive remedy remains whether under Arbitration Act or REJA, but you use different scope and different different statutory regimes, different criteria. So what then is the extent of a scrutiny under REJA? A court who is looking at REJA, when a judgment is challenged on account of fraud, it must be a fraud on the tribunal or the seat court, not a fraud on the underlying fraud that forms the facts of the case. In other words, just as an example, a fraud in relying on a non-existent arbitration agreement, that is a fraud that goes to jurisdiction. But a fraud to seek a claim for a non-existent transaction or relying on fictitious documents, that is a fraud that goes to merits. So the fraud that can be scrutinized is the fraud that goes to jurisdiction, not a fraud that goes to merits. So they call this extrinsic fraud and intrinsic fraud, right? Extrinsic fraud is a fraud that prevents a party from presenting their case. Intrinsic fraud is things like false testimony, use of forged documents, etc. All right, let's skip to the last one, lessons. I've got half a minute left.
Yes.
I know. What lessons can we
for
glean
keeping
from
that.
this case as best practices? Number one, jurisdictional challenges must be mounted early for the tribunal to decide. Number one, go early. Number two, you have an active remedy. Parties have an active remedy to resist the registration in the seat court, right? So jurisdictional issues can be raised there. Number three, if you fail to apply the active remedy, you still have a passive remedy to resist the enforcement in the enforcement court. The enforcement court will take a minimal curial review approach, right? And but on different grounds if you're talking about REJA and Arbitration Act. And number four, this is not an issue that arises in domestic arbitration because the registration and setting aside in domestic arbitrations are always heard simultaneously. This is a peculiar situation unique only to international arbitrations. And with that, I'm half a minute over time.
Thank you very much, King Ho, for keeping to time and for the very, very interesting rundown of this very recent judgment of the federal court and this very interesting interplay between the provisions of REJA and the enforcement provisions of the Arbitration Act. No doubt something that is going to be endlessly debated in the years to come. So thank you very much, everyone, for attending the 33rd BicTok this afternoon. I'm afraid we are past 6:30, so I don't think we really have time for any Q&A. Michelle, are there any questions for us? Or Michelle?
Hi, can you hear me?
Yes.
So, actually, I just sent you a question
Okay.
through your private message. If
Yes.
you prefer to read it out.
Yes, so there is just one. So I think we only have time perhaps for one question. I understand that jurisdictional objections can be raised as a preliminary issue or be determined in the final award. If the tribunal decides in the final award that it does not have jurisdiction over the matter, wouldn't that mean that the tribunal's findings on the substantive issues would effectively be wasted? And if so, does that mean the parties would have essentially wasted time and resources going through the entire process? Yes, so essentially the question is that the jurisdictional challenges can be decided as a preliminary issue or in the final award, which is the person who's asking the question's understanding, which of course is correct. And then I think the suggestion is that if it is decided in the final award rather than as a preliminary issue, there is a waste of time in having gone through the entire process. So I assume what the query is, what is everyone's view on this? So I'm afraid we only have time for this one question, and perhaps I could just hear your views on this, taking jurisdictional challenges as a preliminary issue or in the final award, and if it's taken up in the final award, has there been, and is presumably that the jurisdictional challenge is sustained, then has it just been a waste of time and money for everyone? Yes.
I
Uh,
absolutely
anyone?
think it will be a waste of time and money. And I think that the arbitrators should be responsible enough to deal with jurisdictional challenges straight away and be brave enough to come up with an award. And I think that sometimes arbitrators who defer the findings on jurisdiction are thinking of their own pockets because they want the whole process to go through so that they earn more money. And that is my personal feelings about that. And sorry, that's not very diplomatic.
Thank you, Keng Ho, for those very sharp comments. Nicholas, CK, do you all have anything to add to Keng Ho's somewhat strong remarks on this issue?
Just a quick one, right? Okay, I will not be going as strong as what Keng Ho has done. Okay, but I do concur in some way, not on the pocket aspect, but okay, that the arbitrator, right, should face the issue head on. Now, no doubt the arbitrator, right, can either face the issue head on or defer it to the final award. But arbitrator must also consider that he has a duty, I would say it's duty, to run the whole arbitral process, right, okay, as fast as possible and as economically as possible. So by deferring the whole issue, right, towards the end and then conclude that, yeah, I have no jurisdiction, then when he concludes that he has no jurisdiction, he cannot decide on any issue else. The rest of the issues, the substantive issues in the dispute between the two parties. So those hearing days and times, okay, and the adduction of evidence, all this, right, okay, you can consider them as being wasted. Thank you.
And Nicholas, do you have anything to add to what CK and Keng Ho have said on this?
Maybe it's perhaps just a short remark. I do agree with what Keng Ho has said. In general, it should be dealt with as a preliminary question. But once in a while, there will be certain jurisdictional issues that maybe touch more on the facts of the case, and therefore you might need to go for a hearing by way of witnesses. So there may be maybe a 1 or 0.1% sort of probability that this happens. So the law does give the leeway for that. But in general, in fact, even the PAM, I think the PAM rules does say that also that preliminary should be the way it should be dealt with preliminarily rather than at the final award. So that's all I have to say on that.
Sorry, I qualify what I say because if let's say the jurisdictional challenge comes, for example, whilst trial is already ongoing, hearing is ongoing. So as witness comes up and as witness talks about stuff, and then suddenly we say, hey, you guys are talking a lot about this stuff and this stuff is out of jurisdiction, right? So now on those circumstances, which is akin to a unpleaded case situation, then perhaps it is justified to put it on a final award, right? But if the trial has not started and some counsel says, hey, look, we are now going down a route where there is a challenge to a jurisdiction and the trial hasn't started, you should address it because you don't want people to waste time bringing in witnesses, bringing in evidence, bringing in experts to talk about something that eventually is going to be out of jurisdiction. But if let's say the trial is going on and we are in 5 days out of a 10-day trial and on the day 6, some witness starts going on a frolic and the other side say, hey, look, we cannot accept that this is out of jurisdiction, then I think it is fair for the arbitrator under those circumstances to say, I'll deal with it at the end of the award.
Yes. So I think to summarize everyone's views, starting with a very strong position and then moving to a sort of middle ground, I think there is a sort of balance to be had actually. That there is a time and place for it to be decided as a preliminary issue and a different time and place for it to be decided in the final award. Generally, it should perhaps, especially when it's clear cut, it should be decided as a matter of a preliminary issue. However, where, as Nicholas mentioned, where it involves various questions of fact, then it may be deferred until the final award. And similarly, as Keng Ho mentioned, where it arises midstream, where the trial is already underway, then again, it may be a situation where it may need to be deferred to the final award. So, and I think that is the guidance given in the various texts that have been written on as to whether it should be decided as a preliminary issue or in the final award. So thank you everyone for joining us. Unfortunately, we don't have time for any more Q&A, but the topic that was raised was certainly something that opened up a good discussion. Thank you very much.
Yeah. Thank you very much to our moderator, Mr. Bhaskaran, and to our panelists for this very insightful session, and also to all of you who has joined us today for BicTok session 33. And as a reminder, our next BicTok session will be held on the 22nd of October 2025 at the very same time, virtually, on the topic of navigating the JKR Sarawak forms of contract. So do keep an eye out on our social media pages and website for updates on this and for other upcoming sessions. We look forward to seeing you then, and thank you once again. Have a pleasant evening, everyone.
Thank you, everyone.
Thank you.